speaking with me, Tarun Nangia. A court in France has ordered that properties owned by the Indian government to the tune of 177 crore rupees worth can be seized in a case that involves CAN PLC listed in London and the Government of India. We all know there was an arbitration. The Government of India didn't win that arbitration. It went in favor, the award went in favor of CAN. And to now, receive the money, or they are claiming money. So they approached a court in France. And as you all know now, that 20 properties, mainly residential properties belonging to the Government of India, the court has ordered to attach. So it is a setback for the government in that sense. Now we have to see what happens. Could all of this have been avoided is the question. Primarily because this also involves India's reputation abroad, issues about investment, because global investors, of course, discuss all these issues before investing in a country. All of this gets to be very important from the perspective of wanting foreign direct investment into our country also. We are going to discuss all of this in a very inclusive manner. The court decision just being one of the parts of this issue. May I introduce my panel to you today? I have with me Justice Iqbal Ahmed Ansari. Sir has served as the Chief Justice of Patna High Court. And we also have with us today Advocate Gagan Kumar. He runs a firm called Krishnomics Legal. I would like to welcome both Justice Ansari and Mr. Gagan Kumar. We have with us Simran Brar. She's a partner, looks into arbitration. She is associated with Karanjawala and Company. Welcome, Simran. This is the first time that you have come on Legally Speaking. Thank you so much for sparing time and joining us today. So we will start by laying the ground first in this issue. May I request Mr. Gagan Kumar to lay the ground for us in about a minute and a half or 2 minutes and explain to us where have we reached in this whole issue?
Thanks, Tarun, and thanks for having us today here on this issue, which is nothing less than a good plot of a web series. So the way it is evolving is that first there was a tax demand that was challenged. Ultimately, we had a retrospective effect amendment, which sort of legitimized that demand. And while the matter was still being litigated, the Keynes went into arbitration, and incidentally, they won a unanimous award. So meaning thereby the arbitrator appointed by Government of India also decided in favor of Keynes. Now that led to the next issue of recovery. Now, incidentally, the money from Keynes had already been recovered, unlike in the case of Vodafone. So Keynes, believing it to be a usurious demand, and Government of India always trusting it to be a legitimate demand. So the next step was for recovery, and going by the international arbitration conventions, they filed a recovery suit or an execution for this enforcement of this award before the local courts in Paris. And what we learn now is that there is already an order for attachment. Now, whether that was an ex-party order or Government of India was heard, it is not clear. What it appears is that there was no representation, and government is also caught off guard. So that's the background of the case.
I would like to add, for the benefit of our viewers, the Keynes move is to enforce unpaid dues of $1.2 billion, roughly near about 10,000 crore rupees. The properties which have been attached by the court also include India House, which houses Indian students who live in France. And Ken has also gone ahead and filed a case in the United States of America, seeking to recognize Air India as an alter ego of the Indian state. So we should not be taken by surprise if they manage to attach planes owned by Air India. And whether they can be auctioned off or no is what we'll ask our panelists. I'll go to Justice Ansari at this juncture. Sir, do you think that is a possibility?
So far as the aircrafts are concerned?
Yes.
Yes, it is. there is already a decree award. That award is a decree.
Yeah.
So, pursuant to the execution of the decree or pending execution of the decree, property can be attached.
Okay. Okay.
So
And
it's not very clear to me, honestly speaking, if the execution proceeding has been filed and then the attachment has been asked for, or it was an attachment before the judgment itself.
okay. And in France also, do you think there is a real possibility of the assets owned by the Indian government to be auctioned off and the money is realized by Ken?
So it will be only attached for the purpose of putting it to auction. There has to be some prima facie proof, which of course there will be available with claims, because as Mr. Gagan has very clearly said, there is already a unanimous award given against India.
Okay, point taken. I'll go to Simran Brar as the judge. Simran, could you explain to us in about 2 minutes or so, what does this entail for India? A, is there a real properties that 177 crore rupees worth properties will be auctioned off? B, what will the Indian government do? C, why has this situation come to such a pass? Has the Indian government not moved in time? Is that the reason? Or this is something which was unanticipated?
Right. So Tarun, coming to the first question right away, I believe that the properties that have been attached by the French court in France, for properties to be attached in a nature of this kind, in the sense after an arbitral award, execution of an award, India could possibly state that these are non-commercial properties, because there are various categories of properties under French law that are deemed to be non-commercial. They could be of heritage nature. They could be, I don't know if residential, because I believe some diplomatic officers are residing in some of them. And so that is one way that possibly now the Government of India has to appeal that order, or has to go and put in a representation, in the sense if it was ex parte. So that is one, that the chance for India to now defend execution is now in up to 160 jurisdictions. The treaty is good for 160 jurisdictions, so which is why it's been in the news that they are going to go and execute these awards across jurisdictions where assets lie. So Air India was prior to the French Paris, attachment order. So I guess it's not saying that the Indian government wasn't aware. And also importantly, we filed an appeal, but in the appeal, there has been no stay of the award. So that is one.
Just before you move ahead, for the benefit of my viewers, I would like to tell them that after the Indian government lost the $1.2 billion arbitration that it was fighting with Ken, it moved an application on March 22, 2021, which is this year, and to set aside the December 2020 International Arbitral Award, which it filed at the Hague Court of Appeal. Government of India will vigorously defend its case in set aside proceedings at the Hague. This statement was issued by our Ministry of Finance of the Government of India. Now, India's hearing of appeal against the $1.2 billion award for Hague is listed on September 24th. Now, even as this appeal is listed, they have gone ahead and sought to enforce the arbitral award. Could you explain it to us, Simran? How does this work?
Well, this is pretty much how it works in all jurisdictions, that once an award is passed, it is final and binding on both parties. That is the very genesis of arbitration, and that's the very purpose of arbitration. An award is final and binding, and even India has moved towards a regime where unless a stay is not given automatically anymore when you appeal an award. So Indian government appealing the award and going to the Hague has not granted us an automatic stay, which is why naturally we were subject to these execution proceedings. So that is where it's at, and most jurisdictions follow that.
Okay. Simran, one more case that this company has filed a petition in the courts in the Southern District of New York, seeking judicial confirmation that Air India the national carrier could be classed as the alter ego of the Indian state and thereby be jointly liable for the arbitral award. Where does this go from here? Are we looking at the planes of Air India being seized there?
Well, possibly, like Justice Ansari said. And frankly, if commercial assets, somewhere in the bilateral treaty under which this arbitration was invoked, which was the Investment Dispute Treaty with UK in 1994, sorry. Certainly, if they're commercial assets, they can be. Now, and also depends on the country's law. Like if French law allows only commercial assets to be attached, fine. I cannot say for New York. That would be not my place to say.
I'll go to Mr. Gagan Kumar. Mr. Gagan Kumar, if this were to happen, if Air India's assets were to be attached in New York or wherever those planes are, when they're flying in and out, give me a geopolitical impact, because at least in my limited knowledge, I have not seen such a case involving India. If there is, if you can please share with our viewers for their benefit. Has it happened earlier with India? And if it has not happened, then will it have an impact on India's investment prospects? Because this case has garnered such limelight that it will be discussed in boardrooms and by investment bankers across the globe. And investment bankers have a lot of heft in influencing opinion about investing in any country. Where are we headed from here, Mr. Gagan Kumar?
One thing certainly is clear, that the war with Britain is still not over. So we continue to fight that war. Coming to the issue of Air India, I guess, and with the utmost respect for Justice Ansari's opinion and Ms. Badar's opinion, my view would be that, look, the position of Paris and New York may be a little different. What it appears is that the properties in Paris were clearly owned by Government of India. The case before New York court is that Air India is nothing but an alter ego of Government of India, and therefore it ought to qualify as a state. Now, I am conscious of the fact that there are judgments in India where public corporations have been held to be state within the meaning of Article 12. But when it comes to tax disputes, the courts have taken a contrary view, because treating a public corporation as state is predominantly for violation of fundamental rights. So having said that, even if we look at the New York Convention, when India ratified, it made two reservations to the treaty. And one of the reservation was that only disputes which are commercial in nature can be enforced. Now, if we go further into this, and if we look at the Article 5 of the treaty, which is paramateria to Section 48 of the Arbitration Act, what it says is that if the arbitral award is against the public policy of India, it may not be enforceable. Now, whether recovery of tax would constitute against public policy of India or not, that may not be clear, but we have a few judgments on a different issue, and predominantly, I'm sure my panelists are expert on those topics, but in the Renu Sagar's judgment, what had happened is that FERA, the Foreign Exchange Regulation Act, which was the earlier avatar of FEMA, it was held that violation of FERA is against the public policy. And accordingly, and as recently as last year in NEFET versus Elementa, again, Supreme Court said that if something was exported without approval, then export of such commodity was against the public policy, and any arbitration award may not be enforceable. So the question would really be interesting to see that whether recovery of tax, now, although by virtue of a retrospective amendment, can be held to be against public policy, and whether can there be a second guess when this issue has already been arbitrated upon by the arbitral tribunal at Hague, and can the execution court sit into the judgment again and determine whether this would constitute against public policy of India or not. So going to geopolitical aspects, I think to my mind would be a little premature.
Go to Justice Ansari. Sir, there is CAN has registered an arbitration award in many jurisdictions. The document before me says it's in the United States, the United Kingdom, Canada, Singapore, Mauritius, France, the Netherlands. And the company spokesperson said that France was the latest step in CAN's enforcement strategy of pursuing government across multiple jurisdictions for its unpaid international arbitration award. The company spokesperson of CAN said, our strong preference remains an agreed amicable settlement with the Government of India to draw this matter to a close. And to that end, we have submitted a detailed series of proposals to them since February this year. However, in the absence of such a settlement, CAN must take all necessary legal actions to protect the interests of its international shareholders. So can you share with us that is there a communication breakdown between CAN and the Government of India, and this has resulted, is there some communication gap which is now so large that they were forced to take this step?
Very difficult to say, because the way our bureaucratic machinery moves, though it's a commercial issue, but the fact of the matter remains that the bureaucracy will be looking into it. As far as Mr. Gagan's contention that it is different in United States from what is there in the France, that is true. You see, when the alter ego means that the principal holding or the real ownership of the company is with the Government of India. That's the contention. And if it is found, yes, the person behind the screen, though on the face of it is Air India, but behind the screen it is the Government of India which controls Air India. And in that event, the execution of the decree can be brought against Government of India. I doubt if there is any legal impediment in that. In a situation like this, where the reputation of India as a place for investment is at stake, I think people who are at the helm of affairs, who are still at the helm of affairs, ought to have moved with great alacrity and ensure that these things do not come to such a pass. Otherwise, investors' confidence in India's becoming a hub of investment will be very much shaken.
Okay, point well taken. Simran, is there a way out? I know, of course, you cannot second guess what the Government of India will do. But having said that, where are we headed from here?
So what it looks like, Tarun, as per, I mean, my information would be as good as yours because of reportage, etc. I believe there are certain proposals that have been put forth by CAN to the Indian government, stating a few options. Very initially, what came about was that the Indian government should pay at least the principal amount and could waive off, CAN would waive off the interest component as awarded in the award. So that's one, and naturally one is not privy to what the others are, but apparently recently the finance minister, Ms. Sitharaman, has also stated that they are looking at these options, but naturally for us as a sovereign state, it would be difficult to, naturally it's difficult to take a decision because it would have implications, as Ms. Sitharaman has stated, to have implications on other such litigations, and apparently there are 15 such other pending litigations. And having said that, as Justice Ansari said, that ultimately, if India is to be seen as a place for FDI, then naturally some steps would have to be taken by Government of India to amend this.
Okay.
Sort it out, rather, not amend.
Point well taken. Mr. Gagan Kumar, in such disputes, and as Simran shared with us, 15 such litigations, do you think government will have to think this through too much before it either decides to pay or it decides to negotiate for a lower amount? This way or that, this has to be sorted out because it's not just about this money, but it's about India's story as an investment destination for foreign companies.
Yeah, Tarun, I am reminded of the couplet, Lamhon ne khata ki, sadiyon ne saza pai. So someone made a retrospective amendment. And now the question is, who will bell the cat? We all know that the law was wrong. It should not have been passed in the first place. And in the meantime, government has changed. In fact, past President Mr. Pranab Mukherjee wrote in his book also that although I faced resistance, but surprisingly, after I demitted office, nobody changed the law also. So the question is that now there is a retrospective effect amendment. We know that it is a big spot on our reputation as a country, because where the parliament is using its power to overrule the Supreme Court judgment, although it's not unusual, but looking at the situation where we are today, that a municipal court is essentially going to pass an order attaching the properties of a sovereign state, it looks a little ridiculous. But I think government came up with the olive branch by way of Vivad Se Vishwas scheme, wherein they offered that, okay, pay us tax, forget everything else. But by that time, the taxpayers were emboldened by the arbitral award. And so they decided to recover it completely back. I think a larger view would have to be seen, and possibly government may consider coming out with another amnesty scheme for this class of taxpayer. And hopefully these taxpayers, if in a manner of good gesture and to continue to do business with India, they may come forward and buy that olive branch and settle the dispute once for all, so that everybody ends up saving their faces.
Point well taken. On this note, I'd like to end this episode. I'm sure the viewers would have liked the deliberations today. This is not the last episode on this topic, because this involves about 10,000 crores of Indian government money. It also involves our reputation as an investment destination. I might like to recall that eminent industrialists have time and again spoken on the retrospective taxes issue. So it affects the Indian businessmen also. It's not also about some foreign company who managed to wriggle out of India by selling its assets here and now has won the arbitration. It is a much larger issue. But I would like to thank Mr. Gagan Kumar, Justice Iqbal Ahmed Ansari, Simran Rag, partner Karan Jawala and Company, for sparing their time and joining me on Legally Speaking today. And thank you, viewers, for joining us. Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.